Hi, everybody. This is Tom Hagee at HB Litigation Conferences. We're going to begin in just a few seconds. Okay, good morning and good afternoon. My name is Tom Hagee. I'm with HB Litigation Conferences, and on behalf of our speakers today, I want to welcome you all to this CLE-eligible webinar titled Lien Claims Against Personal Injury Recoveries, What You Need to Know Today. If you have any trouble during the webinar today, please contact GoToWebinar's technical support. Their number is 800-263-6317. So please take note of the survey that's available at the end of the webinar. We ask that you complete it, as it provides us excellent feedback so we can continue to bring outstanding programs like this one. This has been a very popular series that we've been doing with Brett and Franklin, a very hands-on kind of webinar, and so your feedback goes a long way toward helping us decide how to focus future events. We also encourage you to ask questions. Your questions are very, very helpful, and obviously it helps you get the kind of information you're looking for. So please visit the question section on your control panel. Don't forget to hit send, and then we'll comb through those and share those with Brett and Franklin, make sure we get to as many as we can. You can't ask questions verbally, so just please use that control panel and send them to us by text. As I said, it's a CLE-eligible program. I'm going to read 2 CLE codes at random times during the webinar, so please be sure to write them down. You'll receive necessary form after the program by email, so we'll just need you to record those 2 codes on the form and return them to us following the directions that we'll send you by email. So again, please make sure you write down the 2 CLE codes, which I'll announce during the program. So we're thrilled to have back with us two distinguished two distinguished speakers, Brett and Franklin. We've worked with them many times on this kind of webinar, as well as our live conferences. As managing partner of the Lien Resolution Group, Brett Newman's known nationally by plaintiff attorneys for his expertise on claims avoidance and reduction. He founded Plaintiff Solutions in 2002, and recognizing the ever-growing nature of lien resolution and the increased associated liability, he established Lien Resolution Group Solutions. So the objective of these companies is to assist both individual claimants of personal injury lawsuits and mass tort claimants in protecting their proceeds and government benefits. So thanks to Brett for coming back for this one. And again, joining Brett is Franklin Solomon. He's a graduate of Rutgers University School of Law at Camden. He's based in Cherry Hill, New Jersey. He's got a nationwide law practice focusing on evaluation, litigation, and resolution of healthcare lien and reimbursement claims. Franklin represents personal injury victims and their attorneys in defending against claims by health plans and government benefit programs seeking payment of tort recoveries. So with that, gentlemen, the floor is yours.
All right, thanks, Tom. This is Franklin Solomon. We're going to organize this program into several different subject areas based on the statutes and the natures of the liens and reimbursement claims we'll be talking about. We'll be talking about Medicare, Medicaid, Medicare Advantage plans, ERISA, Federal Employees Health Benefits Acts. We've got a lot of territory to cover. I'm going to start out talking a bit about the Medicare statute and liability for secondary payer recoveries. And then Brett will talk a bit about the process of claims resolution with Medicare and how to get that done, and when you'll need Medicare set-asides for personal injury settlements. The Medicare Secondary Payer Act went into effect back in 1980. It's found at Section 42 U.S.C. Section 1395 YB2 of the U.S. Code. The date of its effectiveness is significant because if you have exposure or ingestion claims that arose before that date, any kind of tort liability that arose before that date, that is excluded from Medicare secondary payer recoveries. So for asbestos cases, toxic torts, some pharmaceutical and medical device cases, if the injury occurred before 12/5/80, it's going to be excluded from Medicare secondary payer recoveries. The Act was substantially modified by the Prescription Drug and Medicare Improvement Act of 2003, and it now includes the infamous Section 111 of the Medicare, Medicaid, and S-CHIP Extension Act of 2007, which required direct reporting by responsible reporting entities of settlements involving Medicare beneficiaries. Next slide, please. All right, repayment is required under the Act whenever a primary plan and an entity that receives payment from a primary plan gets any money that ought to be reimbursed to the Medicare Trust Fund. All right, so payment is required whenever it is demonstrated that a primary plan has or had a responsibility to make payment with respect to the Medicare covered items or services. And that payment can be demonstrated, or that responsibility for payment can be demonstrated by either a settlement, a judgment, or a release of claims. Next, please. The Act also includes a section allowing the government to bring a direct cause of action against any one who touches the money in a personal injury settlement that might be subject to a Medicare secondary payer recovery action. And these include insurers, self-insurers, third-party administrators, employer sponsors of group health plans, large group health plans, and others. The United States is permitted to collect double damages against any entity that fails to make appropriate payment to the government in respect of the Medicare secondary payer obligation. Next, please. The Act also establishes a private cause of action that can be used by individuals and other entities to recover damages in double damages for amounts that should have been paid by a primary plan to Medicare when the primary plan fails to make appropriate reimbursement. And that's going to be important for our discussion today because the private cause of action can be used as part of your personal injury claim in order to ensure recovery of the Medicare covered expenses. Medicare secondary payer claims are automatically reduced by a proportionate share of attorneys' fees and litigation costs. Under the Code of Federal Regulations at 411.37, Medicare is required to give you certain procurement cost offsets. You provide documentation to Medicare with your final settlement detail that outlines the total recovery, the expenses on the file, the attorney's fees, and then Medicare does a proportionate share reduction of its claim and issues its demand after that's done. All right, there has been some case law concerning Medicare secondary payer actions over the last few years. The principal cases in the circuit courts of appeal have been the three outlined here: Bradley versus Sebelius, Haddon versus United States, and Taransky versus the Department of Health and Human Services. Briefly, a little word about each. Bradley involved a claim for wrongful death where there was an insufficient recovery. Some portion of the claim was attributable to wrongful death damages. Another portion of the claim was attributable to survival damages. Medicare asserted a claim against the entire recovery. The plaintiffs in the case, the beneficiaries, survivors, went to the probate court in Florida, got an allocation order saying that Medicare was only entitled to recover X percentage of the underlying recovery, because the rest was all attributable to wrongful death damages of the survivors, because it was not survival damages of the estate, of the decedent, then Medicare didn't have a claim. The 11th Circuit upheld that determination and said, where there are competing claims to a recovery, Medicare is only entitled to recover out of that portion of the recovery that represents the survival action damages. Anything that's attributable to wrongful death damages is excluded from the Secretary's reach under the Medicare Secondary Payer Act. Haddon versus the United States involved a similar attempt at apportionment because the plaintiff in that case had been involved in an accident involving a phantom vehicle and another identified vehicle, and was unable to recover full value for the damages he suffered. He attempted to tell Medicare that because he couldn't recover full value for the case, that Medicare was similarly not entitled to recover full value for their claim. The Sixth Circuit did not buy that argument and said essentially that if you release claims for personal injury that include medical expense damages in your underlying personal injury case, you are going to be on the hook for repaying Medicare to the full extent of their claim. So any demonstration of liability is a demonstration of liability that, in the underlying case is sufficient demonstration of liability for Medicare to collect on its reimbursement claim. Finally, most recent case is Taransky, and that's out of the Third Circuit, and that was a trip and fall case or slip and fall case against a shopping center and its landscaping contractor. In that case, Mrs. Taransky recovered only a proportionate share of the full value of her damages because of contributory negligence issues in the case. Medicare asserted a claim against her for reimbursement of covered expenses. Mrs. Taransky went to court and got an allocation order from the trial court saying that because medical expenses that had otherwise been compensated by collateral sources are precluded from recovery in a New Jersey personal injury action, that Medicare would be similarly barred from recovering on its claim. The Third Circuit disagreed and said that her release of claims in the underlying case indicated that she had been paid for medical expenses, and that consistent with the Haddon case, any release of liability for the underlying medical expenses against the tortfeasor is a sufficient demonstration of liability to Medicare for its secondary payer claim. So, next slide. The takeaway from these cases is that to the extent a defendant has any liability to a plaintiff, Medicare is going to be deemed to be entitled to full reimbursement, less its pro rata fees and costs, regardless of any liability or coverage issues. So if you have insufficient insurance coverage on the other side, or you've got contributory negligence, or you've got proof problems with the case that cause you to get less than full value in your recovery, that's not going to make any difference to the Medicare claim. So how are we going to deal with this? Well, the way to deal with this, I think, is to use the Medicare secondary payer private cause of action. There's not a whole lot of case law on this, but there are a few in the circuits that indicate that this is a perfectly sound cause of action to include in your personal injury cases when you're representing a Medicare beneficiary. The principal cases that you want to look at are biomedical applications of Tennessee versus Central States, In re Avandia, which is the Third Circuit's case, and Michigan Brain and Spine, another one out of the Sixth Circuit. In those cases, in biomedical applications, we have a provider that sued health plans as the assignee of the Medicare beneficiary. We had in Avandia, a Medicare Advantage plan was allowed to use the Medicare secondary payer cause of action to sue GlaxoSmithKline as a primary plan as a mass tort defendant. And in Michigan Spine and Brain, we had a healthcare provider who sued an automobile no-fault insurer. And the rule that comes out of these cases is that a primary plan fails to reimburse within the meaning of the private cause of action statute when it causes Medicare to step in and foot the bill for medical expenses, even if it's only temporary. All right, next slide.
Yeah, Franklin, I just want to step in myself here and just read the first CLE code. It's the first CLE code today. If everybody could please write this down. It is 1249. Again, the first CLE code is 1249. So we'll read the second code later. So please make sure you hang on to that and use it to fill out your CLE form, which we'll send you by email after the webinar. Thanks. Franklin, you can pick it back up.
Okay. All right. So rather than fighting with Medicare over whether it's entitled to reimbursement and how much it's entitled to be reimbursed out of your client's personal injury settlements, I think the best course of action now that the circuits have denied those kind of proportionate share reductions is to ensure that the tort defendant, who is considered the primary plan, or its insurer, either one's going to be considered the primary plan in the context of an MSP cause of action, put the costs for those claims where they belong. Under the statute, because the tort defendants and their insurers are liable to reimburse Medicare, it's certainly within the purview of your personal injury action to bring the MSP private cause of action as an additional count in your personal injury complaint. One thing to understand is that the MSP private cause of action is not a qui tam action, and it's got to be brought on behalf of a claimant who has actually suffered a loss, which would include your PI clients. When you plead the MSP cause of action, you name the no-fault carriers or the liability insurers, depending on the kind of case that you've got. They are going to be named the defendants. No-fault carrier, no-fault insurance coverage provided by a defendant, PIP carrier or no-fault carrier, or liability insurance coverage that's provided by a defendant liability carrier is a primary plan with respect to Medicare for payment of medical expense benefits on behalf of the plaintiff. So, that makes them eligible as defendants in your personal injury case, regardless of whether your particular state law allows you to sue the carriers directly rather than just the tort defendant. When you plead the MSP cause of action, you have to plead that that your client actually suffered an injury that's going to result in liability to Medicare. So, as a sample of a pleading paragraph I've included here, as a direct and proximate result of the failure and refusal of the defendant insurer to make payment with respect to the items and services required for diagnosis and treatment, plaintiff has been required to seek and rely on conditional benefits of the Medicare program, exposing a plaintiff to additional cost of financial liability. So that's what will get you, that's the hook for getting MSP damages as part of your personal injury complaint. Next. All right, well, let me turn it over to Brett for just a minute when we talk about Medicare set-asides. But before we do that, let me just note that Medicare set-asides are required in the context of workers' compensation cases, and there are rules that govern how that works. In the context of third-party liability actions, however, there are no rules, regulations, or any kind of guidance as to when a Medicare set-aside might be required. So in some cases, it's a good idea. In some cases, it's not. And it will depend on the individual facts and circumstances of each case. But remember that in a third-party liability case, there is absolutely no requirement whatsoever for a set-aside. All you are required to do is to consider Medicare's interest in future medical expenses that might be incurred by your plaintiff beneficiary, and make sure that those expenses are not shifted to the Medicare program. Brett, why don't you pick it up from here?
Okay, sure. Thanks, Franklin. Thanks, everyone, for listening in today. I apologize in advance for my New York accent and the speed of which I speak on these things. So at the end, I'll provide everybody with my email address, because I'm going to probably promise to email or that I can email you some form letters, documents, template letters that we use in our office and had good success with over the years. So if there's a point person from your office and you'd like it at the end of the teleconference, just shoot me an email, and I'm happy to send it back. And if there are some topics that we brushed over too quickly you'd like to discuss, Franklin and I'll certainly make ourselves available for a conference call to get you whatever you need. Just to finish off on the Medicare set-asides, which could be an hour CLE topic all on its own. I agree completely with Franklin. That's our process in our office. They're not required by law. There's no statute, reg, nothing that requires them. But that is a good point. It is probably a good idea in some cases to do them. And I'm talking outside the world of workers' comp, where the claimant was not injured within the scope of employment, that it may be a good idea to do it. The two cases that concern me the most when we get calls to our office, number one, the case that's litigated, a trial, and there's a verdict sheet of damages, and the claimant is compensated for future medical expenses. The claimant's on Medicare. There's no other source of insurance going forward, just Medicare. I would probably advise to do a set-aside in a situation like that, because it looks like a double dip. The claimant was awarded money for that, and then they're using Medicare. The other case is the one that settles for a substantial amount of money, and perhaps a life care plan was used to help secure or maximize the settlement. Now, if we pull apart a life care plan, if I audited a life care plan, I would bet I'm going to find doctor visits, hospitalizations, and prescription drugs in there, which is exactly what Medicare pays for. So I would probably, on a case like that, now I know when you wordsmith your releases, nobody states in their releases that they receive future medical compensation on a case like that, but that was the point of the life care plan. And although I've never seen a case like that audited, I can't imagine Medicare will ever have the manpower to ever perform such an audit, but I think if they did, it would look like and smell like the client was compensated for that, and if Medicare was the only source of coverage, I would be concerned about a denial of coverage going forward. That's the bad news. The good news is that in almost every instance, the set-aside accounts to pennies on the dollar to any life care plan or awarded trial. Pennies on the dollar. And the reason why that happens is one of the reasons those life care plans or the damages at trial, you're usually claiming all of the medical expenses going forward, meaning nursing home stay, which is one of the most expensive big ticket items going. Maybe somebody's badly injured, they need a wheelchair accessible van every 5 years. In-home Medicaid care, things like that. Those are services that are extremely expensive, especially when you consider medical inflation going forward, but those are expenses not paid by Medicare. So you wouldn't find those expenses in Medicare set-aside. A Medicare set-aside is computed using doctor visits, hospitalization, and prescription drugs going forward from the date of settlement to the end of time based on your client's mortality. There is no medical inflation counted in. So that, accompanied with the fact that those other non-Medicare items aren't in there, really brings down the value number of a set-aside going forward, because there's just no medical inflation, and it drops it drastically. I find on average it's 2 to 6 cents on the dollar to whatever a life care plan is or whatever's awarded at trial. That's usually the average I see on those programs going forward. So now that's all the bad news. The good news is, why would the claimant do it if they don't have to do it? By doing it, we are forcing the government into an obligation. So let's say a client, and it's always easy to talk about the big cases because there's plenty of money to go around, and I know not everybody has the big case, but if we use a larger case, let's just say the case settles for $1 million, the set-aside comes to $50,000, which is nominal to the overall settlement, all right, maybe when dealing with claimant expectations. Here's what's nice. Once the claimant exhausts the $50,000, Medicare is now obligated to come back on and pay, right? So we force the federal government back into paying again at some point down the road. There's a value to that. So you could say, well, what if we don't do the set aside? Well, if you don't do the set aside, and then 8, 9, 10 years later, Medicare gets their act together, and they realize that Mr. Claimant didn't do a set aside, he never computed a set aside, and they start denying coverage. So they say to Mr. Claimant, go ahead and compute a set aside. That new set aside is going to be computed on the new current numbers, which is 10 years of medical inflation from now till then, because you never did one, which means that number is going to be much higher. The problem is that the settlement's not any higher. He's exhausted some of his settlement dollars, if not all of it, and we're computing a set aside on numbers 10 years from now instead of doing it right here and now. So I think that's the value to doing it, is that we pigeonhole Medicare into agreeing, in essence, to some future exposure to the case, and your client has a degree of certainty to what their overall out-of-pocket expense will be. I joke when I do these CLEs in person at firms, I kid with trial lawyers all the time. I know I pay $1,500 a month to insure my family for health insurance. Maybe it's $1,600 a month. I don't know, but it's expensive. Well, if someone told me I had to put $50,000 away today and I'd be covered forever, I would write the check today. I'm going to spend that in 4 years anyway, or less. 3.5 years I'm going to spend that money. But if I could get some insurer to guarantee that they're going to pick up my coverage after a so-called set-aside or deductible is used up, there could be tremendous value to that. So again, even though they're not required, they really are something that is probably healthy to have the discussion on cases that fall into that fact pattern, to see if it is something that is in the claimant's best interest to do going forward. If they don't want to do it, we have some verbiage that Franklin and I use on cases where the client will sign off that they understand the issues going forward, and they've opted not to do the set aside. We got some verbiage for an acknowledgement form. If you'd like that, I'm happy to share it with you. If you just email me, I'll send it to you. We can do it. And then if they do the set aside, we have an acknowledgement. I think it's healthy for the claimant to sign that they understand the process. It explains what the purpose is and what the process is for administration. They understand it, so that if Mr. Smith runs to Las Vegas and blows all the money, he's not coming back and suing the law firm for failure to inform, conveniently claiming you gave him the set-aside check and he had no idea what it was for. So we have some verbiage for that too. Liens, Medicare liens. We're doing this a little bit backwards. Usually we do the lien issue first and then we talk about set-asides after, but since Franklin touched on it, we jumped on that first. Medicare liens. Medicare liens, I'm sure most of the listeners here, if you've been practicing in the personal injury end for some time, there's probably not a chance you've resolved a case and haven't dealt with a Medicare lien, or many of them at some point. But I'm going to touch on a little bit of the process and then some functionality maybe for getting the liens reduced beyond the procurement offset. Well, Medicare lien, most of you probably know Medicare is not under any legal responsibility to negotiate these liens before you settle the case. They can provide you with conditional summaries of what they've laid out and paid for the claimant before you settle the case, but they are not going to negotiate the final settlement or demand until the case is settled. And if you think about it, it kind of makes sense. They're going to reduce their lien for attorney fees and costs, and there's no way they can compute that reduction until you've supplied them with the gross settlement amount and the attorney fee structure, as well as the itemized costs on the file. They need that to work their offset. If you want to get a general idea on how they do it, add up your fees, add up the cost together, divide it into the gross settlement, there's your percentage offset. I don't believe it will ever exceed 40%. So for those of you practicing in states like Pennsylvania, where maybe you have a 40% fee schedule, I think you send the cost in as well, but I don't think you're going to get a further reduction beyond the 40%. States like New York with Med-Mal, where you have a declining fee schedule, I find the offsets there run anywhere from 25 to 36%, depending on the amount of settlement and the cost, because some of these cases are very expensive to bring to trial. But as you all know, you settle the case, somebody in your office calls Medicare, they open up a file with Medicare, and my advice is at the same time, fax in all of the relevant information the same day. If I can also give a little bit of advice for anyone listening in, wait 5 days and then have someone in your office call Medicare again and receive verbal confirmation that the case and file have been opened. One of the ongoing complaints that we've heard over the years, and we still get it, is, Brett, we put this case into Medicare, we're waiting 2 months, there's nothing on the portal, we haven't received the conditional summary, why would something take that long? And then we call up and we find out they don't even have the case open and file at CMS. And the reason is because when you put the case in, if you make a mistake, maybe your fax isn't legible, maybe you put the wrong HIC or Social Security number on it, spelled the claimant's name wrong, date of birth wrong, had the date of loss incorrect. If it doesn't jive up with their system, if it doesn't line up, they will simply shred that and move on to the next case. They do not have the manpower and resources to call your office up and say, we think you've made a mistake, let's discuss it. That won't happen. So by waiting 5 days and calling back, you'll know right away where you stand. If the file's been opened correctly, they are going to tell you they're canvassing for claims in the system. If the file wasn't opened correctly and there's nothing there, you just saved yourself 1 to 2 months of waiting for nothing, of wasted time. So it's a healthy thing to do is to call. That's a matter of process in our office for all of our claim examiners. They do that religiously on every single case to make sure it's done properly. Let's assume it's opened. You wait the 30 days, you receive the conditional summary. It's then your duty to audit those claims to make sure everything is causally related to the case, because many of these claimants have pre-existing conditions. Very important, when you open that file with Medicare, you're very specific to the scope of your injury. So if you have a motor vehicle accident case and your client broke their leg, their right leg, and that's the acute injury, but your client already had a pre-existing condition of diabetes, you want to make sure you're very specific. If not, if you just give them a date of loss, from the date of loss to settlement, you will receive all of the bills Medicare paid, including the diabetes treatments. And then you'll find yourself in a 2-month letter writing back and forth campaign with CMS to have those non-related items removed. So you're going to elongate the process. So be very specific to the injury, especially if your client has pre-existing conditions. Be specific anytime, because you may not even know of a pre-existing condition. So just be specific when you send it in. So let's assume you got it right. They sent you the conditional summary. You audit it for accuracy. You send it back in with itemization of your fees and costs to Medicare. They're then going to canvass their system one more time for claims that are missed. And then they'll work the offset and they'll send you a final demand. Every now and then, probably 50 to 1 cases, we see this happen. The final demand will come back, and it's a little higher or significantly higher than what the conditional summary was. And it throws the whole case into shock. The claimant didn't expect it. The trial lawyer didn't expect it. We didn't expect it. And the question always, Brett, how does that happen? One of usually 2 reasons it happens. Number 1, Medicare simply missed it when they canvassed their claims the first time. It happens. It's Medicare, okay? They missed it. Number 2, more likely, doctors and hospitals have up to 1 year from date of service to submit their bills for payments. So it is very likely that the treating facilities did not submit those bills yet, were not paid yet by Medicare, and that's why they weren't on the first go-round of the conditional summary. So some cases, the number comes in, it's just a little bit higher, okay, something got billed later. If the number looks way off, if you've got a bad injury case and the lien number looks artificially low, it just doesn't look right, then my suggestion is take your HIPAA release, call the treating facilities right away, have someone in your office call, and get an itemization from the treating facilities of everything billed for the services from date of loss to that date. Because then you can see what's really billed. Maybe they just didn't bill Medicare yet, but they have the bill there. It's ready to go for payment through their Medicare portal. And you'll know that's the most accurate way to get the total billing, is asking the treating facilities, the treating doctor, what they billed. And again, very good idea to do if something looks low. In our office, our system notifies our analyst, we have a catastrophic injury, we see it's a big settlement coming on a case, it's a neurological injury, maybe it's a paraplegic, a quadriplegic, a bad brain injury from an auto accident, a workers' comp accident, whatever, and the lien comes in and it's $15,000. That's a red flag right away. Because we all know that those injuries, the liens are always into the hundreds of thousands of dollars. So right away when something comes in that low, it notifies our system, and then the first thing we do is call the law firm and say, we've been retained to handle the Medicare lien. Who else paid the insurance bills? In some states like New Jersey have extended no-fault out to $250,000, and the attorney will say, it all went to no-fault. Great. I know $250,000 went to no-fault first. At least I know where the bill was. Somebody paid. It's a private insurer. Something else. The client switched to Medicare Advantage, which Franklin will get into a little bit, in the middle of their accident, being treated for their accident. So now the bill isn't with Medicare anymore. Now it's with a Medicare Advantage plan. Or it went to the spouse's private health insurance plan at work. So that's, if you see one that's artificially low and you can't find any other insurer that paid it, then you better be prepared. Better be prepared when that final demand comes for a shocker when they find those bills and it comes in much higher. And that's the only reason why I bring that up, because it does happen sometimes. Other bit of advice I'll give you when it comes to liens, if you're dealing with motor vehicle accidents or workers' comp accidents, especially when your office calls and set these liens up, ask if there's multiple files open. As you know, the defendants are required to report these cases. They're really supposed to report them when they settle, but a lot of them jump the gun and report them early. So you're dealing with an auto accident case, no fault. The insurer, they report it way early, even though they didn't need to do it. So as a result of their reporting, Medicare has a no-fault file open. You settle the case, you call up and open a liability settlement. Now there's two files open at Medicare. And I've seen an instance where you'll get a lien letter, you'll pay off the liability file, and then 2 or 3 months later you get another letter from Medicare because the no-fault file is still open. So what we always try to do is we make sure that Medicare at least merges them and closes one of them. When we're coming to settlement, we make sure that both liens are moved into one file if that happens, so that we don't end up with two different liens out there. This is just starting to happen now. I've seen it on a few cases. So you want to make sure there's only one file at Medicare. Anything beyond no fault and workers' comp, I've never seen it happen. So anyone doing just slip and falls, medical malpractice, I've never seen it there. I usually see it when there's another primary payer like no fault, APIP, or workers' comp involved. The other questions we get in our office all the time, okay, Brett, we do this, we got it, the Medicare liens are there, we pay back these liens. Can you ever get Medicare to waive these liens or reduce them beyond the procurement offset, the 30 to 40% that they have to give? Can you get them to go further? The answer is yes, you can try. But what I'll tell you is it's not a verbal request. You're never going to get somebody on the phone to discuss the case with. It's a written request. If you want to see what our template letters look like for waivers and compromises, you email me after the program. I'm happy to send them to you. I'll send them to you in Word format so you can tweak them and change them around all you like. But they're written requests. You'll notice from our letters, we don't spend a ton of time describing the injury. Describe the injury. If you got some sort of bill of particulars or complaint that goes into further depth of the injury, attaches an exhibit and just say, see attached for the injury details. We spend more time describing the reasons for the limited settlement and why the lien was so high and the financial hardship the claimant is going through and will continue to go through, because 98% of the decision is based on that. It's on hardship. If you can't prove some sort of hardship, they're not likely going to waive a lien or compromise it down lower. They're not going to do it. If you're settling a case, for $100,000, and the lien is $950, they're not going to reduce that. They're just not going to do it. I'm talking about the cases where maybe you have an instance where your client was really badly injured in a car accident. He was hit by a 20-year-old kid who was texting and driving, and Travelers is going to tender that kid's $100,000 policy. But you have $1 million injury. That's it. There's no more money. So you're going to settle for the $1 million. The problem is your guy's blown through his APIP or his no-fault coverage, and he's into Medicare now for almost as much, or more than the available settlement proceeds. What do? I would send a letter in right away asking Medicare to compromise that claim. That's the kind of claim that they'll compromise. Now, from the 20,000-foot view that I get and Franklin gets on these cases, because we see so many of the files as they come in for lien work, I can tell you in the last 6 to 7 years, or 8 years now, we have only had one lien waived in our office. Medicare has basically stopped the waiver process. We don't see them giving cases away anymore. We see further reductions. We just don't see waivers. So cases they may have waived in the past, we may see them take an additional 20, 30, 60% off the lien. I just see them waiving liens. So as a result, we don't send in a lot of waiver requests anymore. We opt for the compromise. The only difference between a waiver and a compromise, same letter, same process. Compromise, you make a dollar offer to Medicare to consider their interest satisfied and close the case. That's the difference. We offer $1,000 on every case. And here's our thought process by doing that. If I offer $1,000, and they say no, they either take my 1,000 or they come back with a counteroffer of what they will accept. If you start high, you can't go backwards. So start low and see if they'll take it, and if not, they'll come back with a counter number. And you don't have to accept it. You can appeal it. If you accept it, it's binding. It's over. That's the number. Anything you can get to support your argument and attach to your letter to support you, send it in. Example: tax returns. If you can show your client has not filed tax returns, is filing tax returns, and their income has dropped drastically since the date of injury, that goes a long way to making your argument. So definitely a tax return. Beyond the tax return, bank statements showing little or no money, copy of disability checks, all of that goes a long way to support your position. If you were going to litigate the case, you'd bring as much evidence to trial as you could. Treat this the same way. These vendors and offices get audited that the government retains to do these. They have to justify these reductions or waivers. So give them every reason to do it, to justify it in their audit if they get audited. Now, like I said, we find what Medicare does on our compromises. On the case example I gave you, $100,000 policy limit, they either take our $1,000 or they come back with a counteroffer that I've never seen exceed 1/3 of the gross settlement. The worst they tend to do is a third. So at least you can get something into the claimant's hands, post-settlement. As tragic as it is, and you think they should waive it, at least you can get something into their hands. And again, if you'd like to see what our letters look like, just email me after the program, and I'm happy to share them with you. Another note: Social Security. I'll finish up with this, and then Franklin will jump back in. Social Security. I don't know if your firms are using Social Security releases as a matter of process. What I can tell you is I'm sure you're all using HIPAA releases as a matter of process, but Social Security releases can be tremendously valuable and helpful at time of settlement. And I'll give you an example. If your claimant signed a Social Security release, anybody from your office can take a trip down to Social Security, and you can obtain your client's benefit status right then and there. It's even better if the claimants are cooperative and they can go, because if the claimant goes, they can receive, as a first-party request, by rule, the office has to give them the status. If you go as a third-party request, they may fax or mail it back to you anywhere from 2 hours to 2 weeks later. So if the claimants are cooperative and go, it's great. Send the claimants. You're settling the case. Let's use the same auto accident example I gave you before, but let's flip this one around a little bit. Your client wasn't badly injured at all. Maybe he broke his wrist. He's never missed a day of work. He's back at work. He's 45 years old. But Geico, State Farm, Allstate, whoever, they don't want to give you the $60,000 settlement until they know that Medicare is not exposed. So if you open up a file with Medicare and you go through the process that I started with, you know that it's going to take 2 months, 3 months to get through that before you get the money in for the claimant. And you know your client's not on Medicare. But if your client runs down to Social Security with that form, they will print out a piece of paper stating that he's not a Medicare beneficiary, and they will stamp it. And then you can furnish that to your adversary and you're done. If he is not a Medicare beneficiary, he can't possibly have a lien. Done. If he's not eligible for the benefit, maybe he doesn't have enough quarters into the system, can't be a lien. Done. Maybe he got on the benefit, but the effective date for his beneficiary start date is this March 1st. Still can't be a lien. The worst you'll find out is that your claimant got on Medicare 6 months ago, and Medicare may have paid something. And then at least you should write in and find out if there's anything out there that exposes you or the defense carrier. We find these forms clean up 70-75% of most firms' files right away, because you'll have a degree of certainty. You'll know where you stand in regards to Medicare right away. So those are helpful. Again, this Social Security release, you can get it on the Social Security website. You can get it on our website. Or you could just email me and I'll send it to you. At least if you email me, you'll get the form that we have pre-filled out on the request, so you can see exactly what we request when we send it in. And I'm happy to share that with you. Social Security, the reason why people get on Medicare under age 65, it's a benefit quarters thing. 10 years, 40 quarters, everybody in the country is fully vested in their Social Security benefits. Don't quote me on this. If anyone does workers' comp on the line today, you may know this better than me, but I believe it's 21 quarters, just over 5 years. You may have enough partial vesting to get into the program. The point being that once you're vested, once you're past that vesting point, whether it's the partial number of 21 quarters or full up to the 40, you are eligible for the benefit at 65, or if you get disabled first. So in our tort world, we see this accelerated, right? Because you get somebody who gets injured. As a result of the injury, they go to Social Security. Social Security deems them disabled. 6 months later, they start receiving their SSDI checks. And then 24 months after that, they automatically get their Medicare card in the mail. So to flip it around, you could never get on Medicare in this country under age 65 unless you were deemed disabled first. Have to be disabled first. There's a 24-month wait. If you ever have a client that for some reason their 24-month waiting period was waived, it's one of three reasons: end-stage renal, black lung, or ALS. Anybody with those health issues, the waiting period is waived. They get on the grid right away. Otherwise, it's a 24-month wait. So that Social Security release can also tell you if the claimants have enough quarters into the system to even be eligible for that benefit. So that's another reason why it's very helpful, because you can see, because somebody might have enough quarters to get on the grid, and as a result, they'll never be eligible for Medicare if they're not going to go back to work. You can't buy the quarters and go in. It's not like buying points for American Express or Delta Airlines. You can't buy the quarters. You have to work the quarters and get to deserve to be on that. Otherwise, I think that's the end of my part of the program for now. I'm sorry at the speed I went. It's a lot to get in a short piece so that Franklin can talk about some recent, case law and stuff that's really important. So I'll hand this back off to Franklin now, and I'll stay on for the question and answer at the end.
All right, thanks, Brett. One last point about the Medicare administrative process. If you do have a dispute with Medicare over what they're including in the conditional payments or any other issues concerning reimbursement, you can't go to court on it right away. First thing you have to do is you have to go through a 5-step administrative process, which takes you through Medicare contractors, and then to an ALJ hearing, and then to the Medicare Appeals Council. And then only after you've gone through this 5-step process, if you still end up with an adverse determination, then you can get into federal court and have a real-life judge adjudicate the case. There is an expedited procedure to get to federal court if Medicare at any step along the way does not respond within 60 days and give you your written determination during the administrative process. You can, under Section 1395 FF, file suit in the district court. There are certain limitations about how and when to do that. Look at the statute if that's the way you want to go on that. That's a little too much detail to get into in this program because we got a lot of other stuff to cover. So let's move on now to Medicare substitute plans, which are now known as Medicare Advantage. Next slide, please. Medicare Advantage used to be called Medicare Plus Choice. It is privately issued insurance subsidized by the government and offered in lieu of traditional Medicare benefits that are paid directly by the government. MA plans typically offer additional benefits such as expanded medical expense and prescription drug coverage, and they are governed by Part C of the Medicare statute, which is super important for the litigations that are involving Medicare Advantage plans today. Next slide, please. All right, Part C of the Medicare statute, which governs these plans, has its own secondary payer provision at 42 U.S.C. 1395 W-22A. And it provides that where payment would be secondary under the Medicare Secondary Payer Act, a Medicare Advantage organization may charge in accordance with the charges allowed under a law, plan, or policy described in the traditional Medicare Secondary Payer Act. They can charge the insurance carrier, employer, or other entity, i.e. the primary plan that's supposed to be paying for the medical expenses, or they can bring a claim against the individual beneficiary, but only to the extent that the individual has actually been paid under the law, plan, or policy available to cover such services. Okay, next slide, please. All right, there have been a number of cases concerning Medicare Advantage plan reimbursement rights in the last 10, 15 years. important among them is Care Choices HMO versus Engstrom out of the Sixth Circuit, which ruled that Part C does not create a private cause of action to enforce reimbursement claims. Part C doesn't confer any affirmative right to reimbursement on a Medicare Advantage plan, and any reimbursement claim must be based on a contract provision. So, first thing you need to do if you've got a Medicare Advantage beneficiary as your client is get the contract, which is they call the evidence of coverage that was in effect on the date of injury and for any subsequent year in which benefits were paid. Look in it and see if it has a reimbursement clause. The court cases hold that because any reimbursement rights under the statute are permissive and not mandatory, in order for an MA plan to have a reimbursement right in the first place, it has to create one as part of its contract, and that's got to be part in the evidence of coverage. All right. So one thing that I have seen is a lot of MA plans, rather than drafting a reimbursement clause, a subrogation clause that conforms to the Part C statute, they will just take what appears to be a third-party liability clause out of an ERISA plan or private insurance plan and slap it into the Medicare Advantage EOC. The provisions in those kind of plans typically are wildly in excess of what is actually permitted under the Medicare Advantage statute. So while there has not been any litigation on that issue yet, that is a fertile area for dispute of any Medicare Advantage repayment obligation. Next slide, please. Para versus Pacificare out of the Ninth Circuit in 2013, in a case that reiterates the holdings of Engstrom and Knott versus Aetna was a case out of the Eastern District of Pennsylvania, one of the early cases from 2004. The statutory reference to the Medicare Secondary Payer Act nor to the Code of Federal Regulations granting MAOs the same rights to recovery that the Secretary exercises create any substantive right to a private cause of action. So even though Medicare Advantage plans might claim to have the same rights as Medicare and might claim to be, in effect, the government, it is simply not true. Ninth Circuit says that's simply not the case. The Code of Federal Regulations cannot create any right for a plan that is not a right created by statute, and the statute, as has already been decided, does not actually create the rights for reimbursement to be exercised by the plan. All right. Next slide, please. All right. Avandia, in re Avandia, this was a big pharmaceutical products liability case, went up to the Third Circuit, in which Humana brought a Medicare secondary payer claim against GlaxoSmithKline, who was the defendant in the underlying tort case. Humana was the Medicare Advantage plan, and instead of using the Part C recovery rights under the statute, they brought their cause of action under the private cause of action in the traditional Medicare statute that we were discussing earlier. The Third Circuit said that was okay. They allowed the Medicare Advantage organization to access the private cause of action because by its terms, the private cause of action didn't restrict who could use it, even though there is a section in Part C that specifically outlines the recovery rights of a Medicare Advantage plan. However, by the same terms of that same statute, the private cause of action statute, it appears to be exercisable only against a primary plan that has failed to make payment, because that's what the statute says. It doesn't say anything about bringing claims against a beneficiary. It doesn't say anything about making claims against any other entity that may have received a payment from the primary plan, such as a personal injury attorney who processed the settlement proceeds. It is only exercisable against a primary plan. However, There was a case decided at the end of 2014 by Judge Fallon down in Louisiana called Collins versus Wellcare, where he allowed a Medicare Advantage plan's claim against a beneficiary to go forward by reasoning that the settlement funds were in effect a primary plan because they came from a tort defendant or insurer that was deemed a primary plan under the statute. I think that's wrongly decided because there is nothing in the statutory definition that makes a settlement fund a primary plan. It's pretty specific about what is a primary plan. It does not include a settlement fund, but there you go. That's the, I think Medicare Advantage plans are now looking to expand their reach in claims by using the Medicare private cause of action instead of the Part C recovery rights that they are entitled to. And I anticipate that you will see more of a push to litigate these claims under the private cause of action rather than under Part C or contractual claims. Let's move on to a quick word about Medicaid. Next slide, please. Medicaid statute, the federal statute authorizes states to implement their own Medicaid programs under 42 U.S.C. 1396P. That provides the recovery requirement for Medicaid programs. In a case out of the Supreme Court in 2006 called Arkansas Department of Health and Human Services versus Alborn, the Supreme Court said that Medicaid agencies are entitled to recover only that portion of a personal injury settlement that represents actual payment for medical expenses. So anything else, damages recovered for pain, suffering, disability, other economic losses, anything that is not attributable to medical expense damages is excluded from a Medicaid reimbursement claim. In a subsequent case called WAS versus EMA, the Supreme Court reiterated that determination and said, no, we are serious about it. In WAS, the state of North Carolina had a statute that provided a presumptive share of any personal injury recovery would be deemed to be payment for medical expenses for Medicaid beneficiaries. The Supreme Court said you can't do that. There has to be an individualized determination available to figure out what part of the settlement actually represents medical expenses. So if there has been no specific award of medical expenses or adjudication of medical expenses in your recovery, the Medicaid agencies are entitled to only a proportionate share of the recovery, representing the percentage of its claim as measured by the amount ultimately recovered versus the total amount of damages. So if you have a case that's worth $1 million, you only recover $500,000 on it because of liability issues or coverage issues or whatever problems there are in the case, then Medicaid similarly has to take a 50% reduction on its claim and then further allow an offset for procurement costs, proportionate share of fees and costs on the file. The Supreme Court's holdings in Alborn and WAS have been effectively legislatively overruled by the Bipartisan Budget Act of 2013, which removed from the Medicaid statute the portions that the Supreme Court had relied on in limiting Medicaid reimbursement claims. Although the act went into effect, was signed back in December of 2013, in April 2014, President Obama signed a subsequent measure passed by the House that delayed implementation of the act until October 1st of this year. As of October 1st, state Medicaid agencies will have the option, depending on what their local state statute provides, will have the option of extending their reach in reimbursement claims to all of the settlement that's ultimately recovered in the case. There will be no limitation on Medicaid claims after October 1st, at least not under the federal statute. So if you've got Medicaid cases in process, get them settled now, get your reductions done before October 1st, because this is all going away later this year. All right, moving on to ERISA. ERISA has big news yet again this week because they have a new Supreme Court case. But let's start off with a little background on ERISA liens. First of all, there's no such thing as an ERISA lien. ERISA is silent on liens, creates no reimbursement rights for employee benefit plans. Almost every health plan issued as an employee benefit plan, however, is subject to ERISA. However, there are some that are not. Next slide, please. Okay, so ERISA applies to any employee benefit plan if it's established or maintained by an employer engaged in commerce or by an employee organization representing employees engaged in commerce, or by both. So you've got employer plans, you've got union plans, and you've got employer union Taft-Hartley plans are all covered by ERISA. Next, please. All right, but excluded from ERISA, specifically under the statute, are governmental plans. So any employee of a federal, state, or local government is not going to be subject to ERISA or any employee benefit plan, and church plans, and a couple of other categories that are really not particularly relevant here. Next, please. Okay, so governmental plans include the federal government. Those include the Federal Employees Health Benefits Act, TRICARE, SAMBA, any of the health plans that cover any federal government employees. State and municipal government plans, the Railroad Retirement Act, and Indian tribal governments, all excluded from ERISA, except in the case of tribal governments, where substantially all the work is in essential governmental functions, not in commercial activities. So to the extent you've got employees of an Indian casino, those plans are going to be covered by ERISA. They don't get the exemption. Next. Church plans. A church plan is any plan that's maintained by an organization to provide employee benefits if the organization is controlled by or associated with a church. And significantly, you really want to look for plans that are coming from hospitals, nursing homes, schools, colleges, etc., that have a relation or are operated by church organizations. For example, employees of Catholic Health East are going to be deemed to be members of a church plan. There are a number of hospitals that are run by charitable organizations, charitable religious organizations. For example, we've got hospitals here in New Jersey run by the Sisters of Charity. Those are also church plans. So really look behind, who the hospital or the nursing home is, because those will be deemed church plans. Next. Okay, ERISA preemption. ERISA has an express preemption clause at Section 514 that provides that the provisions of ERISA will supersede any and all state law insofar as they relate to an employee benefit plan. So that's a pretty broad grant of preemption. However, it goes on to include a savings clause that says preemption will not apply to the laws of any state that regulate insurance, banking, or securities. So, all your insurance regulations are saved by ERISA. But then it goes on to include a deemer clause, which effectively makes self-funded plans untouchable by state insurance law, because neither an employee benefit nor any trust established under the benefit plan shall be deemed engaged in the business of insurance for purposes of any law of any state purporting to regulate insurance. Okay, so if you've got an employee benefit plan that is not insured, that it bears its own risk of loss, whether through the general assets of the sponsor or through a trust established to pay the benefits, that will be deemed to be exempted from state insurance law. Next slide. And that distinction was set out clearly in a Supreme Court case from 1990 called FMC versus Holiday. Insured plans can be indirectly regulated by state insurance law, okay, that regulates the plan's insurers. Self-funded plans, however, are exempt from state insurance regulation and the terms of the plan cannot be altered by state law. All right, so what's a self-funded plan? Okay, as I said, first of all, the primary distinction is, does the plan bear its own risk? Or did it go out and buy an insurance policy to cover the benefits and losses of the plan? Then beyond that, you have to look at the particular component of the plan that's paying the benefits in each case, because some plans, even though they're broadly a single health benefit plan, have different components within them. You'll find a medical benefits component that may be self-funded, and you'll have dental and vision coverage that's insured. You'll have a long-term disability plan that's probably insured. So you have to look real carefully at each. You also want to look at whether the plan carries stop-loss insurance. Having stop-loss insurance in and of itself doesn't make a self-funded plan into an insured plan, but it can operate to limit the plan's claim, because if it's covered by stop-loss insurance, you can always make the argument, hey, the plan is only experiencing a loss up to the attachment point of its stop-loss coverage. After that, it's all the stop-loss insurer's problem. So to the extent that the self-insured plan has any claim to make, it is limited by the availability of the stop-loss coverage. Okay, complete preemption. This is the other type of preemption that's applicable in ERISA cases, and this is concerning claims for benefits due under the plan or enforcement of plan terms. ERISA has its own civil enforcement provision at Section 502, and they are distinct. There are distinct sections of it that apply to beneficiaries and to plans. So 502A1B is a participant's or beneficiary's right, and it applies only to participants and beneficiaries, to recover benefits due under the terms of the plan and to enforce rights under the terms of the plan. 502A3 is applicable to a participant, beneficiary, or fiduciary. That is, this is the section that the plan can use to make its to enforce the terms of its contract concerning subrogation and reimbursement claims. Okay, and they can use 502A3 to enjoin any act or practice that violates any provision of this subchapter. So anything that's prohibited or required by the ERISA statute itself, or B, to obtain other appropriate equitable relief to redress those violations or to enforce the provisions of its plan. Okay, so appropriate equitable relief is the limitation on the plan's claims. Next slide, please. Let's talk about insured plans a little bit. Most states have adopted anti-subrogation rules or doctrines that preclude reimbursement under various circumstances. But the extent of the prohibitions on reimbursement claims varies from state to state. So for insured plans that are subject to state insurance laws, you really have to be familiar with the laws applicable to insurance in each particular state to determine what rights and limitations there are on plan reimbursement claims. They come from all different directions. In Montana, the anti-subrogation rule is a constitutional protection of the state constitution. New Jersey has prohibited subrogation claims and reimbursement claims as a function of its state collateral source statute. New York has a specific statute that prohibits subrogation and reimbursement claims by insurers. In Pennsylvania, Pennsylvania broadly recognizes the made whole doctrine, but it presumes there's a legal presumption that if you settle the case, you're receiving full recovery unless there is a determination otherwise. Many, if not most, states also allow for contracting out of anti-subrogation doctrines, such as made whole and common fund, as long as it's spelled out clearly in the contract. There are a few states that have not adopted made whole or other anti-subrogation limitations, but may have other statutes that apply depending on the context of the case, either under their auto statutes or medical malpractice statutes or things like that that will govern allocation of competing claims against a recovery. All right, self-funded plans. There's a form, self-funded plans are required to file, or all plans are required to file with the Department of Labor and IRS, something called a Form 5500 in Schedule A. These are reporting requirements for the federal government that outline who is insuring the plan and how much they're being paid to do so. Plans are also governed by a variety of documents, including the plan document and the summary plan description. They are two separate and identifiable things as a general rule. And the Supreme Court in a case called Cigna versus Amara back in 2011 told us that in the case of any conflict between a plan document and the summary plan description, the plan document controls. The summary plan description in and of itself is merely a summary plan description. It is summarizing and describing the contents of the plan document itself, and therefore without the plan document has no effect on its own. There's also a distinction to be made between subrogation and reimbursement rights for a self-funded plan. Subrogation is a term of art. It allows a plan or an insurer to step into the shoes of the insured to press the insured's right against a third party. There is, by definition, no subrogation claim available against an insured or a beneficiary. What a claim against an insured or a beneficiary is covered by a reimbursement right, which is a separately described right in a plan. When you're interpreting the contract clause that provides for subrogation and reimbursement rights, it's super important to look at the plan year and the date of injury, because subrogation rights, there's not a lot of case law on this, but what cases there are indicate that subrogation rights are fixed on the date of injury or the date on which the plan first incurs liability for payment of medical expenses for that injury. Also, you want to look for any kind of conditional language in the plan, any kind of if-then clauses that say essentially, if you recover for medical expenses in your personal injury case, then the plan gets reimbursed, because then you're in a situation where you're determining how much, if any, of your recovery actually constituted medical expense payment. Finally, one thing you want to look for is whether the plan affirmatively abrogates the made whole doctrine and common fund doctrine. The made whole doctrine says that a plan or an insurer cannot seek reimbursement from its covered beneficiary until that beneficiary has been made more than whole for his other uncompensated losses. That language has to be very specific in certain circuits. 6th, 9th, and 11th circuits require magic language that clearly and affirmatively abrogates the made whole doctrine. Other circuits have a more mushier, we know it when we see it standard, but be aware of what the governing standard is in your particular federal circuit. Next, please. Okay, under 502A3, when a plan brings a claim against your client beneficiary, federal jurisdiction is exclusive. The statute allows the plan to make a claim, but only for appropriate equitable relief to enforce the terms of the plan. Until last week, the most recent decision on this case, on this issue was in U.S. Airways versus McCutcheon, in which the Supreme Court said that unjust enrichment in and of itself is not a defense to a plan contract term. If it's a contract term, it is, in the Supreme Court's view, by definition not unjust, because that's what the contract provides. However, The Supreme Court also said that background equitable rules, such as the common fund doctrine, the made whole doctrine, will apply if they are not expressly contradicted by the contract term. So you have to look again under U.S. Airways versus McCutcheon whether the language of the contract is sufficient to have abrogated both the made whole and the common fund doctrines as the most readily identifiable background equitable rules applicable to these kind of contracts. Next, please. Oh, go back one. Appropriate equitable relief. Okay, I told you this was going to be important. As of last week, the Supreme Court decided a new case called Montanil versus Board of Trustees of the National Elevator Industry Health Benefit Plan, addressing what constitutes appropriate equitable relief. All right, so the Supreme Court reviewed its prior decisions in distinguishing what constitutes equitable relief and determined that you have to have both an equitable claim and an equitable remedy, and that equitable liens are enforceable only against specifically identified funds in the defendant's possession. All right, now, how this case arose was the plan beneficiary had obtained a personal injury recovery. There was a dispute between the personal injury attorney and the plan as to whether its reimbursement claim was enforceable against the recovery. The attorney said, "Listen, we don't think you have a right to any of our client's money. We're going to disperse it in 14 days unless you object." Plan did not lodge any objection. The attorney dispersed the money to the client. The client promptly went off and spent some sizable portion of the money. 6 months later, the plan filed suit. The Supreme Court held that, because the money, to the extent that the money has been spent and is untraceable, that destroyed the equitable lien. The plan's recovery has to be exercised against only that corpus, only that fund that was actually recovered for the personal injury. That's the extent of the plan's claim. That it cannot extend into the general assets of the plan beneficiary, even though the beneficiary has gone and dissipated the settlement funds from the personal injury case. And you have to ask yourself, has the Supreme Court gone out of its mind with this case? Because what public policy is this decision intended to promote, and what are the practical consequences of this decision? And I think it's left us all scratching our heads this week, because it seems that what the Supreme Court has actually promoted is to have claimants' attorneys telling their clients to go out and spend their funds as fast as possible to avoid plan claims, even when there is a legitimate claim for reimbursement. The practical consequences, the obvious practical consequences are it's going to force plans to engage in litigation much earlier. It's going to encourage plans to make claims against personal injury attorneys on various theories of business tort or as quasi-fiduciaries of the plan, and it's going to make settlement of cases much more difficult because there's not going to be any opportunity to negotiate these claims before a plan is essentially forced to file suit against its beneficiary in order to preserve its rights to recovery. But we'll see how things shake out. But I can't imagine. I think the rule that comes out of this case is essentially, no matter how bad you thought things were, a Supreme Court decision can always make them worse.
Okay, Franklin. Before we go to the next slide, we've got about 11 minutes left. I just want to read the second CLE code. So everybody could please write this down. The second CLE code is 6627. That's 6627. So as we come into the final 10 or 11 minutes, if you have questions, please make sure to shoot them over to us. And Franklin and Brad will get to as many as possible. Franklin, back to you.
All right, thank you, Tom. So when when you want to evaluate your client's health benefits plan to see what the reimbursement rights are, you have to request the plan documents and request them from the plan administrator or sponsor. Do not request them from the subrogation agent. Don't request them from Rawlings or Trover Solutions or whoever is handling the reimbursement claim. You have to request them directly from the plan administrator or sponsor because they are the ones with the statutory duty to provide them. The subrogation agent does not have any duty to provide them and will probably give you the wrong documents anyway. What to request, there's a list of a dozen items that you want to request that are relevant to the plan's reimbursement rights. You can review those at your leisure when you get copies of these slides. If you want copies of the slides after the presentation, we're happy to send them to you. So let's skip this slide and move on because we got a lot left to cover still. Okay, what you will typically get right off the bat from the subrogation agent is a summary plan description. And we talked earlier about how a summary plan description and plan document are two different things. A summary plan description is only a description of what's in the plan. The plan document has to meet certain statutory requirements in order to be a plan document. Under ERISA Section 402, it has to be a written instrument, and it has to provide for a named fiduciary. It has to establish a procedure for establishing and carrying out the funding policy and method. It has to include a procedure for allocation of responsibilities for the operation and administration of the plan. It has to include a procedure for amending the plan, and it has to identify the persons who have the authority to amend the plan, and it has to detail the basis on which payments are made to and from the plan. Summary plan descriptions typically do not meet these requirements, so as a rule cannot substitute for a plan document in and of itself. So if there is, so you really need to see the plan document, and it's got to meet all these criteria in order to be a plan document within the statute. Next, please. Okay, so current issues in ERISA litigation are whether an SPD can function as a 402 plan document. There's a number of cases that address this. This has been a hot topic in the last 2 years or so, particularly since the Supreme Court's decision in Cigna versus Amara. There are some cases that go both ways on whether the SPD alone can function as a plan document, but they tend to be a little fact sensitive in when that can be allowed. So I urge you to consider that issue when considering whether a plan actually has a reimbursement right and the language that it's using to enforce that right. Can a plan document delegate authority to a claims administrator or a summary plan description? Again, another question raised by the court's decision in Cigna versus Amara, because the court described the separate functions and responsibilities of the plan administrator and the claims administrator, and the separate functions of the plan document and the SPD. Finally, do plan amendments affect subrogation and reimbursement rights? Under some circumstances they can, under some circumstances they can't. It depends on whether subrogation rights, when subrogation rights accrued. Again, make sure you get all the plan documents and summary plan descriptions that were in effect on the date of injury and on any subsequent date on which benefits were paid for your client. Next, please. When assessing a third-party recovery clause in a plan document or a summary plan description, there's a number of features you have to look for. Does it create a subrogation right? Does it create a reimbursement right? Again, those are two different things. Subrogation rights are exercisable against third parties only. Reimbursement rights can be exercised against the plan beneficiary. Does it establish a first priority claim? and first dollar recovery from any settlement? Does it actually create a lien or a property interest in the settlement proceeds? Does it establish a constructive trust over the settlement proceeds? Does it limit its claim to an identified fund or amount in the settlement? Does it affirmatively abrogate the made whole and common fund doctrines? And is there any conditional language that that needs to be triggered in order for a recovery right to arise? Next slide. Okay, we're running out of time, but I want to just mention briefly federal employees under the Federal Health Benefits Act, because this has been another case that's come up recently. The Federal Office of Personnel Management contracts with 38 plans to provide benefits for its employees. American Postal Workers, National Association of Letter Carriers, Mail Handlers, SAMBA, which covers FBI agents, Government Employees Health Plan, Blue Cross Blue Shield, United Healthcare, Care First. All of these companies have and unions have contracts with the federal government to provide health benefits under the Federal Employees Health Benefits Act. Next. All right, the Act itself contains an express preemption clause at 5 U.S.C. 8902, which provides that any contract under this chapter which relates to the nature, provision, or extent of coverage or benefits shall supersede and preempt any state or local law. Next, please. Okay, in a case called Empire Health Choice Assurance versus McVeigh back in 2006, the Supreme Court said that the reimbursement right based on a FEBA contract is not a prescription of federal law, and that reimbursement rights stem from the recovery on a personal injury claim governed by state law. And the court was not prepared to say that the contract term under a FEBA plan would displace every condition state law places on that recovery. Justice Sotomayor actually wrote the Second Circuit decision in that same case before joining the Supreme Court. And in that Second Circuit opinion, she expressly questioned the constitutionality of the preemption clause in the FEBA statute because it appears to delegate to an executive contracting authority the displacement of state law, which typically would be a function of Congress and not an administrative agency. Next slide, please. After the Supreme Court avoided the constitutional question in McVeigh, and the issue kicked around in the state courts for a couple of years as to when state anti-subrogation law would apply to the federal employee health benefits plans. And two cases were eventually decided, one in the Missouri Supreme Court called Neville's versus Group Health Plans, which found that the insurer's right to subrogation doesn't relate to issues of coverage and benefits, which defines the scope of preemption under the statute. So therefore, because subrogation itself doesn't relate to coverage and benefits, it is governed by state law instead of the federal statute, and Missouri state law prohibited subrogation claims in personal injury cases. Similar decision in a case called Cobalt versus Aetna Life out of Arizona. Next slide. Those two cases both went up on petitions for cert to the Supreme Court, and last summer both were vacated by the Supreme Court and remanded for consideration in light of a new agency rule. What new agency rule, you may ask? Next slide, please. As a result of the Cobalt and Neville's cases, the Office of Personnel Management scrambled and rewrote its rules to include a specific provision that subrogation and reimbursement clauses are mandatory in FEBA contracts. Subrogation and reimbursement provisions constitute a condition or limitation of benefits that relate to the nature, provision, and extent of coverage, directly addressing the Supreme Court's decision in Nevels, or the Missouri Supreme Court's decision in Nevels, and that furthermore, all these federal employee health benefits contracts provide a first priority right, regardless of the nature of the underlying recovery. All right, that rule was published in the Federal Register on January 7th. Public comments closed on February 6th, and the rule was adopted with lightning speed on June 22nd of last year. And thereafter, a case that had been wending its way through the 10th Circuit called Helfrich versus Blue Cross Blue Shield Association was decided, and the 10th Circuit ruled that FEBA now does preempt state anti-subrogation law. It gave Chevron deference to the OPM rule that had been adopted in June, and it declined to address the constitutional issues because the court decided were not properly raised in the district court. Okay, I see we're at 3:30. We'll skip this discussion of the Federal Medical Care Recovery Act, but it's simply another provision of federal law under which certain governmental benefits plans, including military and veterans plans, can exercise subrogation and reimbursement rights. But we'll have to save that subject for another day. You will, however, have the slides for it in whatever's provided after this program.
Franklin, the only thing I wanted to add, and usually when we do these programs, we don't get into war stories because they could take it offline. But there was a case, I think it was 2 summers ago, that I wanted to bring to everyone's attention. And if you mentioned it when I jumped off the program for a bit, you can stop me from telling it again. But it was a private health insurance lien that Franklin and I were brought in on 2 summers ago in New York case. The woman was elderly. I think she was about 78 years old. The case settled, and she was terminally ill, and it had nothing to do with the case. But she was literally day to day with her illness. And in that case, I believe the company Ingenix put the defendant on notice and their carrier that there was a lien, and they were going to sue them for this lien. So even though they settled for X amount of dollars and cents, the defendant wouldn't execute releases until plaintiff counsel took care of the lien issue. So you can see where this was going. If this woman died, this case was gonna go away. So in a frantic panic, he was calling us. We got the subro agent Ingenix on the phone, and we knew her. And right away, the lien went from $120,000 to $80,000. She took a third off the lien almost without asking. She just took it off, which we thought was odd because, as all of you know, they rarely just give you anything. You really have to press them to get some reductions. And after Franklin did some digging around online, we were able to determine that the coverage was afforded through her husband's employer, which was the Archdiocese in New York. And as Franklin alluded to earlier, that the religious organizations are not afforded any ERISA protection on these cases. There was no lien on this case. And when we brought it to her attention, within 5 minutes, we had a no lien letter on our machine. Obviously, the conversation didn't go that nicely, but you can get the point. You really need to, open the hood and kick the tires on these things because you need to see what you're dealing with. And those subro agents, there's no way that they don't know who the employer was, who their clients are that they solicit to recover these liens. And it's really disingenuous what they do in a lot of cases. And you really have to do your homework to see what's out there. So with that, I'll stop on that story and let Tom open it up for questions and answers.
Yeah. Well, you just did. So go ahead. You guys you have some questions already submitted?
Yeah, I see.
Franklin,
I see some submitted. Let's go through them. I'll just go through them as quickly as I can. Okay. Can an ERISA employer's health plan sue plaintiff's counsel for dispersing funds to his client without their consent? Again, this is the attorney liability question. District courts around the country have been all over the lot on this issue, and I got to say it depends. Nothing stops a plan from suing anybody, and there is some case law that allows the claims to go forward. There's a case out of the Sixth Circuit called Longaberger versus Colt, in which the Sixth Circuit said, yeah, it's okay for a plan to sue the personal injury attorney, but it seemed that that case specifically contemplated circumstances where there was an automatic lien that was created over any settlement funds. It's a self-executing lien, and the attorney was on notice of the lien, and and just went ahead and dispersed anyway. And the Sixth Circuit allowed that claim to go forward. That's contrary, however, to decisions out of the Eighth and Ninth Circuits. There's one out of the Eighth Circuit called Drury Industries, and another out of the Ninth Circuit called Hotel and Restaurant Employees versus Gentner. And in those cases, the circuits decided that absent a specific agreement of the personal injury attorney to protect the plan's interest in the settlement proceeds, there was no cause of action to be had against the personal injury attorney. Now, there are cases percolating in the district courts around the country that involve claims against personal injury attorneys on various theories, including business torts, interference with contract, and also there's this extension of a Supreme Court case called U.S. versus Harris Trust, that the plans are using to allege that personal injury attorneys are somehow in a quasi-fiduciary relationship to the health plan, and therefore can be sued under ERISA. We'll see how those cases play out, but again, there is not a clear-cut answer on that question. Okay, how can you protect the client whose Medicare comes from a Medicare Advantage plan against all future medical costs? The client's carrier may change from year to year, so an agreement with Humana in 2016 to release liens for future medical costs may not limit United's ability to claim MSP reimbursement in 2017 when it becomes the client's Medicare insurance. Okay, so switching plans. If you're switching to between private insurance plans, there is nothing you can do. Settlement of the case is settlement of your case. If your case involves a large future medicals component, the fact is that like any other health plan, the terms and conditions of plans may change year to year. So there is nothing guaranteed about the benefits that you might receive in future years from any given health plan. I think it's going to be a tough question, and I think it's I think that to the extent that you're making arrangements with one plan to protect it from future medical costs, that's not necessarily going to inure to the benefit of any future medical insurer. So if you're switching off to from one carrier to another in a future year, I don't think you have any obligation to that future carrier, as long as you're not switching the shifting costs to the Medicare program. There's no rule or regulation that I'm aware of that that even contemplates that kind of a change.
Well, not only that, but these plans, these Medicare Advantage plans, the benefits are paid from Humana or MediBlue, which is Blue Cross. They're not paid out of the central Medicare trust, so it's the trust fund. So, and they're all competitive firms vying for the business. They're not talking to each other on their claims paying. So there's just no way that Humana is going to know what MediBlue paid when you switch that plan.
Next question is, so Medicare will not negotiate a lien down until after a case is settled. Will a Medicare Advantage plan negotiate a lien down before settlement? Typically, no, although, if we can get them involved early enough in the case, we may be able to, and we can get a sympathetic ear at the plan's subrogation agent, depending on who the plan is and what the relationship is like. We may be able to get them involved to to at least work out a formula for plan reimbursement, at the end of the case. Ordinarily, and I can see it from the insurer's point of view, ordinarily there's not a whole lot of incentive to settle their claim until they know, how much the ultimate recovery is, because then they can start making arguments about, oh, well, you got so much money, and therefore, you need to pay us back everything, and then be in a fight over that. But it is, at least in theory, possible to get folks to agree in advance, particularly when you're getting close to a settlement point, where you can say, okay, if their settlement is between X number of dollars and Y number of dollars, we'll pay you back on a sliding scale. If we can get more than that, we'll pay you back more. If we get less than that, we'll pay you back less, or subject to some floor or to some cap. There are opportunities to negotiate. There's nothing that obligates the plan to negotiate, however, other than the threat of undermining the settlement altogether. Which is the ultimate hammer, is that your client will blow up the settlement if there's nothing, if it's just nothing left for him at the end of the day.
Okay, Franklin, I think we're going to have to wrap up. Did you have any final comments?
No, there's just one more question that I did want to address. It says, so what is the story now in New York with respect to claims by ERISA funds for recovery of employers' health insurance company in light of amendments to the GOL? And that's in reference to a statute enacted by New York, GOL 5-335, that prohibits reimbursement claims by insurers. So if you've got an insured plan in New York, any reimbursement claim and any subrogation claim against a settling party to a personal injury suit is now prohibited. Self-funded plans, however, are going to be allowed to exercise whatever rights are available to them under their contracts. So.
Okay, great. Franklin, thanks for that. We give everybody a few extra minutes. I hope that's a good thing. So once again, you've been listening to lien claims against personal injury recoveries, and you've been listening to Franklin Solomon of Solomon Law Firm in New Jersey, and Brett Newman of the Lien Resolution Group in New York. You can see on the screen Brett's email address. If you want to send him questions or requests for the forms that he mentioned, please go ahead and do that. We also said we'll get out to you the presentation itself, and you will also see our survey. So we do appreciate that very much. If you could just take a minute to fill that out and tell us what other kind of things you're looking for. If you're looking for more of these kinds of webinars and what subjects you'd like us to address, we'd appreciate that very much. You'll also get an email from us with the CLE information. You've got the 2 codes, I hope. So you'll need those to fill out that form. Get those back to us, and we'll process your CLE. So with that, Franklin, thank you very much. Brett, thank you very much to you and to all the attendees. You have a good rest of the day. This is Tom Hagee from HB Litigation Conferences.
Thanks, guys.